Okay, so thanks, Landon. So because I've moved the quiz portion into the afternoon and you haven't had a lot of time to sort of let this sink in, I want to start with a quick overview of the rules of this little quiz. And then we'll get into the presentation of a few different provisions that were in employment agreements that have been tested by the courts. And the idea here is I want you guys to be the judge. Those who are here in person, by a show of hands, and my friend at the back running the AV is going to push a poll after each slide where I show you the language in a contract, and everybody at home can then vote. And we should be able to see a tally of what people think. We'll sort of judge that by what happened in the case. So again, an overview of the rules. Implied common law presumption of reasonable notice. And you're allowed to rebut that presumption in a contract, but only outside of Quebec, of course. Our friend Robert has left, but can't do it in Quebec. If the contract of employment clearly specifies some other period of notice, whether expressly or impliedly. That's what the Supreme Court said in Hodge. The courts read all clauses pertaining to entitlements on termination as a whole. So anywhere in your contract where there's language about entitlement is fair game per Waxdale. And so you've got to be careful to take a look at various places and where you might have inadvertently made contractually enforceable provisions, limiting or prescriptive. If any part of that whole falls below the Employment Standards Act, then the whole termination clause and all of its iterations throughout your agreement are null and void, and the employee gets that presumption of reasonable notice that it becomes an implied term once again. I will say it's not going to be relevant here, but I didn't mention it in my presentation because I've gone a little bit over, but the courts have said that it's the employee who gets to decide whether to challenge your contract. So then as an employer, you can't draft a clause that's very generous to an employee and then find a place somewhere else where you violated the Employment Standards Act as a way of getting out of giving this generous package to an employee. That's too bad. Contra preferentum, you've given them a nice contract. They get to say, I have no problem. Give me my 24-month package, even if there's a just cause provision somewhere else that violates the law. They get to complain, you don't. Enforceability of a termination clause is determined by the words of the clause alone. So you don't get to say, well, we always comply with the ESA or even do that in the circumstances. If the clause says we're not going to comply, that's enough. The clause falls down. And the courts will apply that contra preferentum rule, but they're not allowed to sort of strain to find ambiguity, looking for a completely twisted and unreasonable version of the interpretation just to say that your clause is a void and must fall. Okay, so that's the sort of review. And now let's get into the examples. Okay, so you be the judge. Contract number one. Everyone take a moment, review the language. So termination without cause. There are obviously many other clauses, but I'm taking you to the one that's most salient in our situation. So we may terminate your employment at any time and in our sole discretion by providing you with written notice and or pay in lieu of notice. The notice or pay in lieu to be provided will be 2 weeks plus any applicable notice and severance requirements in accordance with the Employment Standards Act. So we're going to give you even more than what the ESA might require. If pay in lieu of notice is provided, you will receive only your base salary and employment-related health and dental benefits for the applicable period, save and accept short-term, long-term disability, et cetera, et cetera. So by a show of hands in the room, and by a poll pushed online, please, Q. What do you guys think? Hands up if it's enforceable. Hands up if it's not enforceable. Okay, seem to be split 50-50 in our room. Let's see how the polls are going online. All right.
81%.
Right. So we're set. We've got a pretty clear decision from the gallery at home. And so what we've got, I guess Q, if you could put up the slides again, is that the courts have found the clauses to be unenforceable. The employee must receive all compensation they would have received had they worked that minimum notice period under the ESA. It's unlawful to restrict someone when they're receiving pay in lieu of notice to base salary. So in this case, that was the issue. It was saying you only get your base salary. There are other things you're entitled to receive. For example, you're entitled to vacation pay that accrues on that base salary at a minimum during the notice period under the statute. And that was enough to make the otherwise slightly enriched provision for when you're not terminating for just cause a violation of the act. Number two, the township may, at its sole discretion and without cause, terminate this agreement and the employee's employment thereunder at any time upon giving the employee written notice as follows. And then it goes on to iterate all of the things that the Employment Standards Act requires in a fairly rich package. So looking at that language and thinking back to the review we did, by a show of hands, how many people think that this clause is enforceable? How many people think it's unenforceable? Okay, I'm seeing a little less equivocation. I like it. So it seems like we're fairly consistent on both ends, although we still do have a fairly large yes pile here. This was not an enforceable provision. This comes out of a decision called Dufault, which I did mention briefly during the presentation. And the issue here is that the court found that there are circumstances where the ESA might say you're not allowed to terminate. And so in that clause, the employer reserved the right to implement a termination at its discretion. Well, sometimes it's not their discretion. Sometimes the ESA bars that. It's not permissible. And so the court in this case, which again, the appeal was argued today, so we might find out if everybody still agrees with this concept. But for now, the law is that reserving the right to terminate at your discretion or at any time is sufficient to say that you're implicitly saying we can terminate for reasons that might be unlawful. That is a reason for invalidating your contract. Not sure how much I agree with that lingo. I think that it should be fairly clear what it is they were trying to describe was the circumstances, not really reserving that right to do so unlawfully. But the court was pretty clear in that decision that that is what was done implicitly. And finally, here we are. You be the judge. We've got, if your employment is terminated with or without cause, you'll be provided with only the minimum payments and entitlements, if any, owed to you under the ESA, et cetera, et cetera, et cetera, et cetera. It looks starting to look pretty good. You understand and agree that compliance with the minimum standards satisfies your common law and contractual entitlements. Let's take a moment, guys. How many people by a show of hands think this is an enforceable provision? Anybody? Okay, and by a show of hands, how many people think it's not? I think you guys have all gotten used to the no button. This was a victory for employers. Okay, I wanted to end on a positive note. This is the Birch decision in data stealth. The court here found that this is exactly what you're allowed to do and that there's nothing ambiguous. There was an argument that by failing to expressly reference some things about what the ESA might provide, that somehow that rendered things ambiguous. The court said no. It was clear the parties intended to waive the common law here, and that employment standards only was applicable. So that is what was found. So good job, guys. Overall, we did a very good quiz, and thank you all for your attention.
Okay. So I don't have any slides for you, so you'll just have to listen to me, unfortunately. But I'm talking about the Workers for Workers Act 5 and then the Workers for Workers Act 6. As some of you may recall or be aware, there was this Working for Workers Act 5 that was passed some time ago, but there were provisions that hadn't yet been brought into effect. As we heard from Allison, the provision regarding not being able to ask for sick notes to support sick leave under the ESA came into effect October 28, 2024. And as well, the maximum fines for failing to comply with an order from the Ministry of Labor have been increased from $50,000 to $100,000. Now, before you panic, I'm not aware of any fines for failing to comply with an order in anywhere near that range of magnitude. So I don't know if this actually means anything, but it's on the books. And as well, under the Occupational Health and Safety Act, the definition of workplace harassment is now expanded to cover harassment through information or communications technology. So surprise, surprise, people can be harassed through technology. I don't think we really doubted that before, but it's now enshrined in the Act. And the application of the Occupational Health and Safety Act has now been officially expanded to cover telework performed at private residences. Okay. So then, just like last week, I think November 27th, the government introduced the Working for Workers Act 6, Bill 229. So it has not been passed into law. It's at the first reading stage, but given that, Doug Ford has a majority, it most likely will be passed into law and before the next election. And there are a few acts that will be amended if this legislation passes. First of all, under the Employment Standards Act, there's now a long-term illness. There will be a long-term illness leave of 27 weeks without pay if an employee is not able to work because of a serious medical condition. Now, I think this is actually a no-brainer and has been a curious gap in the Act up till this point, because we've got leaves dealing with, employees that have to take care of family members and who have critical illnesses or serious medical conditions. But now the individual employee themselves can have this leave. Now, as most of you are probably aware, under the Human Rights Code, there's also the duty to accommodate, which would actually likely give somebody an entitlement to a much longer leave than 27 weeks if they have a serious medical condition. So don't read this section and assume that you can then terminate an employee on a medical leave at 28 weeks without any legal repercussions, because you might find out that's not the case. There's also a new child placement leave where an employee could receive up to 16 weeks of unpaid leave if they come into the custody or care of a child through adoption or surrogacy. There are some amendments to the Occupational Health and Safety Act. The most significant being that maximum fines can be increased for a second or subsequent offense resulting in death or serious injury. So that's a $500,000 minimum fine if you have that. Sorry. So in other words, if you have more than one fatality or serious injury within a 2-year period, you could be facing a $500,000 minimum fine under the Act. And as well, there's an amendment that would come through about personal protective equipment, that employers must ensure it's a proper fit or appropriate circumstances, and the government may make regulations for PPE and clothing. And then there's going to be a new Skilled Trades Week Act, which one of my clients is Skilled Trades Ontario, so this is kind of a big deal for them. And this will introduce, the first full week in November will be Skilled Trades Week to promote skilled trades in Ontario. There are some amendments to the Ontario Immigration Act that would essentially prohibit misrepresentations and filing false documents in support of a Ontario immigration application. And then some provisions with the Workplace Safety and Insurance Act, which are fairly narrow, including presumptions for firefighters in respect of if they come down with certain forms of cancer, and legal immunity for the board directors, officers, and employees of the board, which I'm sure no one really cares too much about. So that's it for my topic.
Well, I certainly care about the legal immunities for officers of the WSIB when I live in workers' compensation land for much of my practice, but it's not entirely surprising. There has been a rash of lawsuits that have been filed against the WSIB and human rights claims and such. So the board has clarified that one is not able to sue officers of the board, and that is probably a great relief to those who actually sit in those positions. Workers' compensation update. It's not been a hugely, as Landon alluded to, there haven't been a huge amount of developments in the board, but there's one good news. Who likes getting money back? Well, it seems to be a government trend these days, right? They've got Doug Ford writing checks, Justin Trudeau writing checks, and now the WSIB is getting in on the act. They are giving employers in February, these are Schedule 1 employers only, so if you're public sector, this doesn't apply to you, but all of you in the private sector are going to be getting a giant refund from the WSIB. The bigger your premiums are, the bigger your refund is going to be. The board, in its usual, in its sort of usual vagueness, has not exactly announced how the refund is going to be calculated. But having made some inquiries, I think you can say it's safe to say that you might be getting a check back for anywhere from 50 to 60% of your annual premiums to the board. This is because of a surplus in the WSIB. The board's been performing this. We've obviously been in record territory in the stock market, which has been good for the WSIB's bottom line. So it's at a surplus like it has never had. But even a decade ago, the board had a very significant unfunded liability. That's all been wiped out. And so they're now presenting employers with checks. There is one exception to that, though, is if you are an employer that has one or more convictions, either under the Occupational Health and Safety Act or Workplace Safety and Insurance Act, within the last 3 years, you don't get it. Also, you will not get a refund if you've had a traumatic fatality, which means if you had a fatality, whether you've been convicted or charged under the OHSA or not, if you had a fatality, you're not going to be getting a refund. But in terms of, that's a relatively small percentage of employers, so it's something to the effect of 99% of employers are going to be getting these refunds. And that has nothing to do with your actual experience rating, good, bad, or indifferent. So it's certainly an initiative that is a welcome one for employers. I mean, it may very well suggest that the board is charging employers more than it ought to be if it is generating this kind of revenue. The other thing I wanted to quickly talk about is there's been a rash of cases at the tribunal talking about when and where an employer can, when basically a harassment that results in a WSIB claim can prevent a wrongful dismissal case. There was a landmark decision at the divisional court a few years ago that made it clear that that's a very difficult thing to do. And all the cases since have basically confirmed that if you have an employee that has been getting a WSIB entitlement for stress or harassment, or basically, stress arising from harassment, that is not going to take the employee's right to sue away. That basically right to sue for wrongful dismissal is, so basically what the board is saying is that all of this law, all the tribunal said the only thing that you really can take away is potentially torts like intentional infliction of mental stress, things along those lines. But the vast majority of the lawsuits will survive, interestingly, even though lawyers have been very creative in trying to use the shield, because ordinarily workers' comp is a trade-off, right? You can't sue for personal injury if you are in a circumstance where you have a workers' comp claim. But so they've chosen to interpret the stress very narrowly. Even if you have a wrongful dismissal case, which is in essence a constructive dismissal case based entirely on the harassment, it's still going to go forward. And that, from the perspective of employers, is frustrating. Lastly, still on the stress claim topic, we're at a record number of stress claims at the board. Since the policy, we know that there historically, of course, it was very difficult to file stress claims, but these claims are becoming more and more common. And I can speak anecdotally that I've just seen some stress claims where employees are just off for unbelievable lengths of time. So I think it's very important that when you have these stress claims to manage, to look at managing the costs of them. Lastly, no real significant reforms for the board on the horizon, but I would not count on a pre-election lottery win next year. I think this payout that we're getting is a one-time payment and may very well be a political dynamic to it in light of the fact we're likely potentially looking at a provincial election in coming up in the spring. That's it. Thanks.
Seven minutes.
Well, no, actually, I would bring this in close.
Oh.
How many minutes do I have? I have 7 minutes.
Oh.
Okay. I gotta do this really quickly. Okay, I want to talk about damages awards very briefly, just a couple of areas of interest, because there are always different areas of interest in damages. The first is the 24-month maximum. We normally think that there's a 24 months maximum threshold for damages for wrongful dismissal. But, you know, these cases are always dependent on their facts. And I want to talk to you about two cases where that was exceeded. The Millwood and IBM case is a case of 38 years of service. For some reason, 38 years seems to be the popular number. I don't know why. Employee age 62, non-executive but managerial. Employee, no direct reports. So not in the classic case to go to the far end. The employee sought 30 months. The employer said, no, it should be 20 to 22. They couldn't settle it, so they went forward. The court awarded 26 months in that case, plus an additional month because this case was going on during the period of COVID, so there was a COVID-related extension. The Court of Appeal upheld that decision. And the main reason for exceeding the 24 months, which has to be exceptional circumstances, in this case was held to be the lack of transferable skills. And there's a bit of a theme here. Usually when you exceed 24 months, it is because of a lack of transferable skills. In this particular case, this individual was involved in a company in a function that was very limited to knowledge of how IBM does things. And that's very common in somebody who's worked a whole lifetime for one company. So this employee was awarded salary and RSUs and pension, no discretionary bonus though, for a total of 27 months. In Lynch and Avaya, Canada, again, 38-year employee, age 63. The employee sought 26 months in the claim, ultimately was awarded 30 on the basis that when they came to oral argument, the employee counsel was arguing for 36, so nothing turned on what was in the statement of claim. The employer argued for considerably less. Again, 30 months awarded on the basis that the employee was a key performer, had made a lot of contributions to Avaya. Now, frankly, that's what they were paid for 38 years, but be that as it may. But the main reason was very specialized experience. So again, lack of transferable skills. And they lived in Belleville, meaning the available jobs in the area would have been significantly limited. And finally, a case just to show that you don't only get to 24 months if you've got 24 years or more. Mazimenko and Zim, a 2024 case, 58-year employee, 20 years, almost 21 years of service, upper management, but it was a niche industry, ocean freight. She had no other Canadian experience. Not that that would necessarily matter after 21 years, but in any event, it's really the niche industry that did it. She asked for 24, the employer asked for 18 to 20. She was awarded 24, even though she had only 20 years of service. So you can see that there's a push, an upward kind of push. And of course, we're always dealing with older employees. The second area I wanted to talk about is bad faith damages in recent cases. Landon talked about the principles behind this. The first case is Krompotic and Thunder Bay Electronics, the 2024 case involving a building management supervisor with almost 30 years of service. He had back surgery. He'd been back for 2 hours and some bright spark decided to fire him. So of course he sued and claimed aggravated and punitive damages for being terminated. He was awarded $50,000 in aggravated and moral damages for the employer not being candid and obviously for terminating him after having him back to work for 2 hours. The argument came down to he couldn't do his job anymore, but of course they really didn't much care whether that was factually true or not. They just wanted to get rid of him. He didn't get mental distress damages per se because he had no medical evidence of an effect on him of the mental distress. But you'll see from the next cases I'm going to talk about that there's a real blurring of lines here about whether the employee has to have personal medical stress associated with this condition, or whether these numbers aren't really just punishment for the employer. In any event, this was called aggravated and moral damages. In Willata and Caristar, I can't read my own writing here, the employee had been recruited from 3-year employment, had 14 and a half months of service, got terminated. The employer, for unknown reasons, really alleged that the employee had really quit, which was kind of a silly argument to make since it clearly went on to terminate him. They didn't give him a termination letter. They didn't provide him with his ESA entitlements. They made a really silly comment about him needing to get a job because he had an autistic son, which was obviously extremely hurtful. And in the end, he was awarded I think it was 14 weeks. Yes, 14 weeks of notice, so slight extension on the notice period because of the recruitment, and $10,000 of what the court termed were moral damages. So you can see that there's some interchangeability of terms here. In the Wilds case that Landon made reference to regarding an employment agreement, this was a 52-year-old executive assistant with 4.5 years of service. Again, this was sloppiness dealing with the ESA. They didn't pay out her ESA entitlements. They didn't pay her expenses. Her ROE was issued late. There was no proof of mental distress, again, in terms of medical proof. But the court awarded $10,000 in punitive damages, called punitive damages in that case, and awarded her 2 months of notice for the termination itself. So you can see that these last two cases, the amount of money at stake in terms of the notice period was modest, but the employer really made a mess of things by not complying with the ESA, not issuing the ROE on time, and so on. So if I can urge you to do one thing, it's comply with the law as far as the ESA is concerned, and don't get into silly arguments about, you know, whether an employee really quit or was dismissed or not. I mean, there's nothing turns on this, but it just will potentially double your damages just because the court is angry with you about being a jerk, frankly. And, you know, as I said, sometimes these things are characterized as aggravated or moral or punitive damages, but you can really reduce it to the court thinking you're a jerk, I think. The last positive thing I want to tell you about is a case I happened to come across and I just loved it. So I'm going to tell you about it. It's Gannon and Kinsdale Carriers, 17-year employee, worked as a receivable office person for 15 years. Then they got dispatcher title and duties added to that. They were going to be terminated and the employer went out and looked for alternative employment for them with a competitor, found them a potential position. The employee declined interest before a job offer was even made to her. She said she only wanted accounts receivable and office duties. The new job would have been the same pay, dispatcher job with a receivable and office duties. She sued, and the court held that she failed to mitigate her damages by following up on this opportunity. And that's one for employers, because I've certainly had employers on occasion ask me about trying to find jobs for employees. This is a case where the employer actually did that, and they were rewarded for doing so by the employee losing the case with costs presumably awarded in favor of the employer. So I thought you might like that to end on a high note there. Thank you.